Thank you, Judge. May it please the court, Mr. O'Brien, Ms. Palumbo, ladies and gentlemen of the jury, before I begin my closing argument, I want to, on behalf of Mr. LaPrinzi and my office, on behalf of Captain Laughlin and the Acton Police Department, I do want to thank you for your jury service. We know that we're taking you out of your ordinary lives, your ordinary routine of what you do each and every day, and that this is a inconvenience for each and every one of you. We appreciate that. This morning, obviously, was unforeseen, but you know that jury service is a necessary component of the judicial system. It cannot function unless we have individuals, in this case, 15 of you, who are willing to be fair and impartial and to listen to all the evidence. And so I thank you. This is the closing argument. It is our opportunity as counsel to sum up what we believe the evidence has shown and to point out to you any reasonable inferences that you can make from that evidence. And when the 12 of you go back into that jury room, hopefully you will come to a common conclusion in this case as to whether the defendant will unite, is guilty or not guilty of each of the crimes in the indictment. And I ask you to keep several concepts in mind when you're back in that jury room. First, I know that when we picked you as jurors in this case during the voir dire process, we ask you to wipe the slate clean, to not let any factors in your individual lives affect your ability to be fair and impartial in this case. However, when you go back into that jury room and you start evaluating the evidence and applying it to the law, we don't expect you to decide this case in a complete vacuum. Rather, use common sense. Common sense that each and every one of you have obtained through your life's experiences. Common sense in evaluating evidence to determine, is this truly self-defense? Was the shooting of Keith Johnson justified? Should the defendant avoid legal responsibility and legal consequences for his actions that day? Use your common sense. The other concept is the burden of proof. And the judge read to you pretty lengthy instructions, and I think we talked a little bit early on that what you're going to be asked to do in this case is weigh evidence. And you're not just going to be weighing it one time. You're going to be having multiple tasks. The state has the burden to prove guilt beyond a reasonable doubt as to each of the elements. And once we prove those elements, the burden switches. And I have a little picture here of the scales of justice. And this is ultimately what you're going to be asked to do. And if you find that the state proved in each and every element, you're going to start anew and you're going to decide, hey, did the defense prove to me by a greater weight of the evidence that this was self-defense? The third weighing that could go on is, was it proved to me that there was this mitigating circumstance, what I'll call passion and provocation? So you don't shift the burden. It is not for the state to prove to you beyond a reasonable doubt that this was not self-defense. That's for the defense to do. And another important concept when we talk about this and we see Lady Justice there is that she is blindfolded. She's weighing the evidence just like you're going to be asked to weigh the evidence, and you're to do it objectively. Without prejudice, without sympathy. To be objective balancers of the evidence and come up with your decision. And you're going to hear that from the judge in her final instructions. And you're also going to hear that if the defendant is found guilty, that sentencing is up to the judge. But that'll be her determination. And so when we talk about that scale, we're not putting sympathy on there, we're not putting prejudice on there, and we're not putting on there, I wonder what the sentence is going to be in the case. The judge threw a lot of law at you. A lot of law. And I'm going to try to give you a little bit of a Cliff Note version because I know it's confusing. I know that you will have those instructions in that jury room. But I think the more you hear it, the more you'll be able to digest it and start making sense of it and put it in an organized fashion. Count one, the defendant is charged with murder. We've called this purposeful murder. And ultimately, as to count one, you're going to come back with one of three verdicts. You're either going to find the defendant guilty of murder, guilty of voluntary manslaughter, or not guilty. One of those three decisions are going to be made by you. And when you have those jury verdicts, you're going to be filling out one verdict as to count. What is murder? It is the purposeful causing the death of Keith Johnson. And when we talk about purposeful, one of the instructions that was just read to you, if you find that the defendant used a deadly weapon against another in a manner calculated to destroy life, you may, but are not required to infer the purpose to cause death from the use of the weapon. And we don't just have the fact that he used a gun in this case. We also have the fact that when he used that gun, when he pointed that .357 revolver, he pointed it directly at the chest of Keith Johnson. Didn't point it at a leg, at an arm, at the tire of that dirt bike. He pointed it to the heart. That, ladies and gentlemen, is a purpose to cause death when you aim and you fire a gun directly at the chest of another individual. Count two, which we've kind of referred to as felony murder. Once again, you get kind of a different route, but it's going to be kind of the same concept. You will have one of three things happen in your deliberations and your verdict. Guilty of murder in count two, guilty, this time it's called involuntary manslaughter, or not guilty of the offense. And you will have multiple verdict forms, but you will only be filling out one as to count two. And felony murder is that the crime of felonious assault was committed. And as a result of committing that crime, Keith Johnson died. And counts 3 and counts 4 are felonious assault, and there's multiple ways of committing felonious assault under the criminal code. Okay? One is that, as you see in count 3, you cause serious physical harm to another person. You knowingly do it. So an example of that would be you beat up somebody, you break their nose, their cheekbone, give them a concussion. That would be that form of felonious assault. It would also be shooting them in the head. The other way you can commit felonious assault is to cause or attempt to cause physical harm by means of a deadly weapon. So once again, if you shoot at somebody and you miss, that's another way, that's felonious assault. In this case, a gun was used, a gun was fired, and Keith Johnson was hit. So both felonious assaults apply in this case, and that's why you have charges as to both. And if you find that the defendant committed one or both of those felonious assaulted and Keith Johnson died, that is felony murder. So the difference, count 1 is purposeful murder, an intent to kill, to take life. Count 2, we do not need to prove that it was Mr. Knight's intention to kill Keith Johnson, just that it was an intention to harm the other person. Now, once the state meets those elements, and I submit to you that we have through that evidence, then at that time the burden shifts. And it is up for the defense to prove the affirmative defenses. And because William Knight in this case indicated that Keith Johnson was coming after him, was intending to kill him, there is the affirmative defense of self-defense. Facts show that he was 20, 30 yards away, that there was never any conflict between the two of them, but he claims Keith Johnson was trying to kill him that day, and so you will analyze whether there's self-defense for William Knight, worried about his own life, worried about him suffering great bodily harm. And there's a 3-pronged test, and the judge read it to you. I'm not going to go over word for word again, but you'll also have that in your jury instructions. There is also defense of another, being his daughter, Michelle, and his son-in-law, Curtis. And it's important to note that the defendant has no greater rights than Curtis and or Michelle. So when you heard that one of the self-defense prongs is that he was not at fault in creating the situation. Now, if Curtis Gill was at fault in creating the situation that gave rise to the crime, then you're done. No self-defense. Don't get into the mindset of what's reasonable, what the defendant believed or did. It doesn't matter whether this defendant created the situation. If he's claiming defense of another and Curtis Gill created or was responsible and is at fault for creating the situation, then self-defense or defense of another's fails right then and there. And those, once again, are the elements or the instructions you were given in regards to defense of another. What did the evidence show? It started out at the beginning. A dirt bike. A Yamaha YZ80, and the defense has said several times, this isn't about a bike. This is absolutely about a dirt bike. This is about recovering that bike. This is about righting a wrong. This is about trying to be a man. And when we go to the timeline of events, they're pretty simple. February of 2016, that dirt bike was stolen. Let's say December or January after that, Keith purchases the bike from his mom's neighbor's son. What's interesting is Brandon Ward didn't have to reveal this. It goes to his credibility when you talk about his testimony, but he told the police right away, and he told you they knew it was stolen. They knew that. And then on March 20th of 2017, the bike reappears on a website of the internet, and it's for sale. And the defendant and his group gather all types of information, an abundance of information. Who's selling the bike? Justin Badgett. What Justin Badgett looks like, there's a picture of him on the website. Where he lives, there's an address. They talk to him by phone, so they have a phone number now. They have a picture of the dirt bike. They have an abundance of information at that point. And why I bring that up is, one, they could have given that all down with the police, have a great start to the investigation. They'd be able to solve it. They'd be able to find the person responsible and ideally find the dirt bike. That's the hope. But they didn't want to wait. And you will hear, and you will have Michelle's 911 call in which she says early on, a cop was supposed to come out here with us to retrieve the bike, but they ended up getting another call. So they're well aware that the police aren't going to be there. To be clear, I'm not blaming them. I mean, they did the right thing. They called the police. I think you can understand the frustration that the police didn't show up immediately when they called. You can understand the desire of wanting to have that dirt bike back. But the reason why that's important, that they were willing to go there without the police, is that's the mindset when they're going to Danby. Because you really have two different scenarios that you can accept, two different factual scenarios. You can believe the defendant and the defense that he's just a peaceful man, that when he went to Danby, he wasn't even thinking about the gun. Didn't really know if he had the gun, and that really his only purpose and his only mindset being there was so that the dirt bike could be placed in the back of his truck. Or you can go where the evidence supports and what common sense tells you, that there was no way in the world they weren't thinking there could be a conflict here. They might not just hand over the dirt bike. There might be a conflict here. We're still willing to go without the police being there. And because the defendant was armed and ready to go. He was ready to be a man. He was ready to be a protector of his daughter. You heard about one of the text messages that was from Curtis to Michelle, getting frustrated here, also getting amped up. Well, those are emotions you can imagine were going around. Being frustrated, being amped up, we know that the defendant not only had a .357 revolver on this person, he had a loaded .357 revolver on this person. He had 2 speed loaders, 2 sets of 5 bullets each on his person. So once again, is he the peaceful person who's not even thinking that he has any kind of gun on him? Or is he somebody there, ready, willing, and able for conflict? You know, when they arrive on Danby, that although he initially pulls up right behind Curtis's car, right where everybody is, and Michelle gets out, he doesn't stay there. He can stay there if he wants. But he drives down the street, turns around and stays several houses down. And I submit to you, he's getting in a tactical position so he can see the situation, be in control of the situation, and if necessary, use that gun that he just got a CCW permit for. I mean, it's nonsensical and irrational to think that none of that was going through his mind. It comes out at that time that Curtis eventually, when he's there with Keith, Curtis he's the true owner. He's not willing to pay a dime. And at that point, the evidence doesn't support Mr. Knight's version that there's 4 African American males surrounding Curtis. At that point, there's a disagreement. There's yelling. They're swearing. But it's going both ways, as you heard. Curtis yelling and swearing. Keith yelling and swearing. And ultimately, it is Keith who's trying to leave. You heard from multiple witnesses, including 2 witnesses on the defense side, and there's only one person who says that Keith was jamming his bike into Curtis 7 to 10 times. That's the defendant. Everybody else paints a clear picture of Keith Johnson just wanting to get out of there. You heard the word retreat in self-defense. Keith Johnson is trying to retreat. And you first heard it from Justin Badgett, who said that when he started up the bike, Curtis grabbed onto the handlebars, and Keith tried to scoot and move away from him and get away. And we know it's at that time is when he gets those injuries. They're minor injuries. But he does get injured trying to hang on to that bike because that's his goal. He wants that dirt bike. He's there to recover. When Keith Johnson gets away, here's the scene from the street, he doesn't get far. He loses control. Brandon Ward, Isaac Sprangman, they both described fishtails, that he fishtailed out, bike went down, and the bike turned. Curtis Gill indicated the bike roughed up against one of the cars and it turned 90 degrees. However specifically he went down, it is clear that he didn't intentionally go down and then turn the bike to come back. From going down, from hitting the cars or fishtailing, that bike turned and now is facing in a different direction. And we know, what is Curtis's reaction to that? Is he in fear of his life at that point now that the bike has turned? No. Curtis Gill, he's not scared at all. He starts in the direction to get his dirt bike back. Keith picks up that bike quickly, once again, trying to get out of there, hits the throttle, the bike goes up, and it's at that point, ladies and gentlemen, that he loses his life because down the road, where almost nobody has noticed, is William Knight in his tactical position with his gun, decides to fire at the chest, and Keith Johnson dies on the street there at Danby Avenue. I mean, assessing the danger at that point. When you look at that distance, it's a short distance. Everyone agrees that Keith went down. So this is not a situation of Keith Johnson riding down the street, getting up to 30, 40, 50 miles per hour and going in somewhere. He's down on the ground, the bike's not moving, he gets the bike up and he goes a couple feet. A couple feet at that point. So that bike is barely moving at that point. He didn't have a gun, he didn't have a knife, they weren't beating up anyone as I gave you the example of felonious assault. The only thing that happens is that bike, that front tire goes up in the air. And that's the front tire. Captain Laughlin, when he was on the stand, he was asked on cross-examination, well, can a truck be a deadly weapon? Yeah. Can a motorcycle be a deadly weapon? Well, to a lesser degree, yeah. Well, what about a dirt bike? Can a dirt bike be a deadly weapon? I suppose so, but to a lesser extent. In the words of Dr. Braun, anything's possible. But ladies and gentlemen, once again, use your common sense. When we talk about the threat that Keith posed, I mean, how often in your life experiences have you heard somebody using a dirt bike to commit murder, to kill people? Let alone three people. I've never heard that. And you've got to put that into the equation of what's reasonable. Was his actions reasonable? Was his actions necessary? And there's also an instruction there when we talk about reasonableness is, was this just excessive? Maybe you can understand the whole situation having some fear, but was this going overboard to fire your gun at that point? Because if the defendant used more force than was reasonably necessary under the circumstances, then once again, self-defense and defense of another fails. You cannot use excessive force. I submit to you that one of the most compelling pieces of evidence in this case is the perspective of Michelle Gill. Michelle has her husband. Shirley loves her husband, cares about him, is worried about his welfare on a daily basis. And Michelle is right there to see the exact same things that William Knight sees. And although 1 year later, when she testified on the stand last week, she indicated the bike was coming at her, but I submit to you that I tried to point out that's the first time she ever said that. That when this happened, and everything was fresh in her mind, and she had just experienced this. In fact, while she was experiencing that, none of that came out. Nothing about the bike was coming at me or coming at Curtis. I thought Curtis was going to get killed. I thought I was going to get killed. It's almost strictly every time Keith is trying to get away, Curtis is grabbing on. I don't want Curtis to grab onto him, so I try to get him off. And next thing I know, the bike goes down. Within seconds after this occurs, you can hear the true impressions of Michelle Gill.
Okay, wait. What just happened? What's his name? I don't know. Is he black or white guy? Okay, and he just got your father-in-law?
No, the guy who's running to the bike. Okay, the guy who's like, he's trying to take off on the dirt bike for my husband to take it away. My husband was driving off and trying to stop him from doing so. And then my father-in-law, he's there. My father is wearing his garter.
Okay.
Her first impression at 911, not that her husband was in danger, not that she was in danger, but that Keith was trying to get away, and my father, who has a carry concealed weapon permit, shot. And it's consistent when the question was asked, and you say, oh my God, I can't believe what you just did. I can't believe that. And then she goes to the police station, 36-minute interview, and she provides a consistent version every time. I pulled away, and my husband pulled away, and the next thing I know, the dirt bike is sliding, and I didn't even honestly know that my dad had shot him. The second version, I ran after my husband. I was trying to get him off, just get him off the guy, just trying to stop him from latching on to him. Question, when the bike skidded out, were you like about to get hit or anything? Answer, no. And then the third time during that interview, it's like I said, the bike took off, my husband's grabbing on, and I went to try to get him off, and I backed away. My husband's still kind of there, and then he backed away, and then the bike is down. So she provides, and she has no bias to make this look bad for her father, obviously the exact opposite. But her version, once again and again, with her perspective, is self-defense was not necessary, and defense of another was not necessary. Michelle and everybody else's perception, I think, establishes two things clearly. One, Curtis initiated the physical contact by grabbing on to those handlebars because he wanted that bike back. And two, Keith was fleeing, not attacking. Fleeing, not attacking. And you compare what seemed to be a pretty consistent version from all those witnesses to when the defendant took the stand, and he told a version of 4 guys being around Curtis, that after the bike goes down, Keith gets off the bike, takes 6 steps towards him. And I believe he said that, at some point Keith has the look of menacing and mayhem in his eyes. That he goes back to the bike and that he's looking right at Mr. Knight with that look of menacing and mayhem. I submit to you when we talk about his personality and something, that's not just overreacting. That's being untruthful, ladies and gentlemen. Being untruthful to avoid ultimately the consequences of his actions. Again, when we talk about Curtis's actions, if you conclude from the evidence that Curtis was at fault for creating the situation by grabbing the handlebars when Keith wanted to get away, by being the only one to make physical contact, by then when Keith goes down, going towards Keith, if you make the conclusion that it was Curtis who was at fault, and remember Gerald Bench's testimony that Kurt said to him one way or another, "I'm taking my bike," then that's the end of defense of another. You don't even get to the mental state. You don't consider the defendant's thought process. Because in that 911 call, you start hearing his thought process. First words when he gets on that phone, "They tried to kill my daughter." He was trying to run into my daughter, into my son-in-law, and into me. Right away, he's trying to claim self-defense because Keith Johnson had this dirt bike that was stolen. Ladies and gentlemen, this is not self-defense. It is not self-defense. And it is not defense of another. And when we hear from Dr. Brahm about characteristics of the defendant, that he's overreactive, that he's on the edge, that he has bad judgment in a stressful situation, that he has short fuse because a family member is involved, and he likes to prove himself as a man. All these traits are consistent with him committing murder. Yet the defense argument in this case is that, well, that's just who William Knight is. But this is William Knight here on this board here and in that report, and therefore he should be excused for his actions. Well, if committing a violent crime and you're overreactive, on the edge, have bad judgment, short fuse, if that's an excuse, ladies and gentlemen, well, that's a great portion of crimes and criminals in our society. They're overreactive. They make bad decisions. They're over the edge. I mean, that's what crimes are all about. Yeah, there's those criminals who are cool, calm, and collected and evil, but for the most part, criminals make decisions because they overreact, they have short fuses, and they have bad judgment. And Dr. Brahm was a hired gun in this case because the facts in this case don't support self-defense or defense of another, and so it's a desperate attempt to try to create it where it doesn't exist. The facts don't support it, so let's hire an expert. Try to convince the jury that William Knight is peaceful and overprotective, and so instead of focusing on the facts of this case and what actually happened on Danby, focus on Mr. Knight. But don't be fooled that Dr. Brahm's 6 hours with William Knight, now you know William Knight. She gets paid. She got paid $5,000, $6,000 for this. Sure, if this case turns out in her favor, it'll be in the stories section of her website soliciting more business. And the fact that she had an agenda and a bias is clear by how she went about doing her work. She interviewed defendant, defendant's sister, defendant's daughter. All individuals who have not only support the defendant, but are all hopeful that the defendant avoids the responsibility, avoids a conviction. Worked 40 years, but not one fellow worker is interviewed. Lived in this community all this time, but not one neighbor. Do you think maybe those people may have some insight, really, other than the individuals that were interviewed? Now, raising the issue of race, when it's not relevant, just to evoke a response or some passion, that's not seeking justice, ladies and gentlemen. But race is relevant in this case, and it was relevant even before we did opening statement, because we spent a day and a half bringing each and every one of you individually into the judge's chambers, and defense counsel asked you about race. And so I submit to you that it's a red flag that Dr. Braun never even approaches the subject, never addresses it in any manner. Because we know right off the bat, factually, that this is an older white man killing a young African American. Would it be worth asking some questions about that? When we're talking about what is his mind state, what's his mental state, how did he approach making decisions that evening? We do know from his 911 call that he's saying they tried to kill my daughter. We know that in addition to Keith, he's saying there's 3 other African-American males surrounding Curtis, even though we know from the evidence that the only other African-American male there is Brandon Ward. We heard on the witness stand saying he's been bad dreams, that these people are harming my son and daughter. And once again, the clear facts of the case is that this conflict with the disagreement was just between Curtis and Keith. So ultimately, though we went through all your feelings, isn't it relevant what his feelings are from his life and how that affected his thought process that night? I submit you can't ignore it. But even if you choose to throw that issue out, the defense of self-defense and defense of others, when you take the life of another individual, is a serious burden and it's a significant burden. William Knight has a daughter, has a family. Well, Keith Johnson has children. Keith Johnson has a family. And so when we start evaluating the burden in this case, we can't forget that it is a significant and a serious burden when you choose to utilize a gun and shoot another individual in the head. Because there's no going back. I submit to you that CCW permit went to his head and was part of everything else that night. That it wasn't reasonable. It wasn't necessary. The defense is claiming that it's his personality traits, ultimately, which justify that act, which make him not guilty by reason of defense of others. And I submit to you that being overreactive, being over the edge, he's an exaggerator. The term that comes to my mind is he is somebody who is a drama queen, saying that danger lurks around every corner in our world. And I have this CCW permit, and I'm going to start shooting out this danger. Under the law, that is not self-defense. Under the law, that is not defense of another. In your common sense, you know that that is not self-defense. And as a result of the focus on the evidence in this case, I respectfully ask you to find the defendant guilty of the murder of Keith Johnson. And I thank you.